EU Whistleblowing Directive has now taken legal effect across the European Union, and Member States are in the process of transposing the directive domestically. The directive aims to introduce effective, confidential and secure reporting channels for whistleblowers and provide them with robust protection from penalisation for making whistleblowing reports.
The Irish legislation to transpose the EU Whistleblowing Directive, the Protected Disclosures Amendment Act 2022, amends the existing Act from 2014 and will come into effect on the 1st of January 2023.
This means that from the 1st of January, public sector employers, private sector employers with 250 or more employees, and employers who fall within the scope of certain EU laws in areas such as financial services must have formal reporting channels and procedures in place for workers to enable them make protected disclosures. It also means that all employers will be impacted by the other aspects of the new legislation, such as expanding the category of workers who can make a protected disclosure, reversing the burden of proof in penalisation claims, and the introduction of a swathe of new criminal offences for non-compliance with the legislation.
At A&L Goodbody, we have been advising clients for many months now on the new regime, and in particular on the need for clients to update their policies and roll out training programmes to ensure compliance with that regime. Some of the most important changes employers need to be aware of are as follows.
Not only can employees, contractors and agency workers make protected disclosures, but so too can shareholders, volunteers, board members and even job applicants and former employees.
In order to qualify as a protected disclosure, the information disclosed must, in the reasonable belief of the worker, tend to show a relevant wrongdoing and have come to their attention in a work-related context. Under the 2014 Act, there are 8 categories of relevant wrongdoing, such as that an offence has been committed or that there has been a failure to comply with a legal obligation. These categories remain, but have been expanded to also provide that reports can also be made about certain breaches of EU law.
A new development is the inclusion in the legislation of a clarification that reports of interpersonal grievances exclusively affecting a reporting person do not constitute whistleblowing reports. A classic example of an out-of-scope report in this regard would be a bullying complaint that exclusively relates to the whistleblower. This certainly is a welcome clarification, but its effectiveness in practice remains to be seen, given the scope for whistleblowers to frame the reports in such a way that they are not presented as raising issues that exclusively affect them alone.
Probably the most noteworthy development is the requirement for many employers to establish and operate an internal reporting channel and procedure, with failure to do so constituting a criminal offence that can be prosecuted by the WRC. Key procedural requirements of the new internal reporting channels are to acknowledge receipt of the report within 7 days, to conduct an initial assessment of the report to decide if there is evidence that a wrongdoing may have occurred, and if so, to take appropriate action, which may mean a full investigation, and to provide the reporting person with feedback within 3 months, and if requested further feedback at 3-month intervals until the procedure is closed.
Employers in scope are required to ensure provision of clear and easily accessible information to workers regarding the procedures for making reports. And in practical terms, we think this means that a whistleblowing policy really is essential, that must be accessible by the workforce.
While protection from penalisation for having made a protected disclosure is not new, the new legislation will bolster the existing protection. It will reverse the burden of proof in penalisation claims, putting the onus on employers to prove that any alleged penalisation was not prompted by the making of a report. There will also be greater scope for employees to apply for injunctive relief to the Circuit Court to restrain acts that are alleged to constitute penalisation. The new legislation takes effect on the 1st of January 2023. From this date, many employers will be required to have a whistleblowing policy in place that complies with the new Protected Disclosures Act and also be in a position to process whistleblowing reports in line with that policy. This will inevitably necessitate staff training, particularly for those tasked with following up on whistleblowing reports.
It really is essential employers know whether they are required to have a new whistleblowing policy in place by the 1st of January. All private sector employers with 250 or more employees are certainly required to. However, employers with far fewer employees may also be required to. For example, if they operate in the financial services sector, such as insurance companies, credit institutions and regulated investment firms. The introduction of this legislation really is quite a significant development for all employers in Ireland. And for that reason, we recommend that all employers familiarise themselves with the new legislation, as it will likely impact them in one way or another. And a good starting point in that regard would be to read the recently published interim government guidance on the new Protected Disclosures Act. The employment team here at A&L Goodbody have published lots of content on the new whistleblowing regime this year, which you can find on our webpage at www.anlgoodbody.com. And of course, we're here to assist with any individual queries you might have, so please do not hesitate to get in contact with your usual employment contact as you get to grips with the requirements of the new regime over the coming weeks and months.